The landscape of data protection and privacy is complex and ever-evolving, with regulations like the General Data Protection Regulation, GDPR, in the European Union, the California Consumer Privacy Act, CCPA, in the United States, and many others around the globe. Understanding the key terms and concepts is essential for organizations and individuals alike to ensure compliance and protect personal data. This article delves into these terms, providing a comprehensive overview for anyone looking to deepen their understanding of data protection and privacy. Personal data refers to any information relating to an identified or identifiable natural person, data subject. This can range from direct identifiers like names and social security numbers to indirect identifiers such as location data or IP addresses. The protection of personal data is at the heart of privacy laws worldwide, recognizing the rights of individuals to control information about themselves. Data processing encompasses any operation performed on personal data, whether or not by automated means. This includes collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, dissemination or otherwise making available, alignment or combination, restriction, erasure, or destruction. Understanding this term is crucial as it underpins many obligations and rights under data protection laws. Data controller is the entity that determines the purposes and means of the processing of personal data. They hold the primary responsibility for ensuring compliance with data protection laws, including managing consent, data rights requests, and data protection impact assessments. Identifying the data controller in any data processing activity is a key first step in applying data protection principles. Data processor, in contrast to the data controller, is an entity that processes personal data on behalf of the controller. While they do not have the same level of decision-making power over the data, processors are required to handle the data in accordance with the controller's instructions and the law. They have their own specific legal obligations, particularly around security and confidentiality of the data processed. Consent is a fundamental concept in data protection, referring to any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which they, through a statement or a clear affirmative action, signify agreement to the processing of personal data relating to them. Consent must be obtained without coercion, must be withdrawable at any time, and must be as easy to withdraw as it is to give. Data Protection Officer, DPO, is a mandated role in certain organizations under GDPR. The DPO is responsible for overseeing data protection strategy and compliance. They act as a point of contact for data subjects and the supervisory authority, provide advice on data protection impact assessments, and monitor compliance with data protection laws. Data breach involves the unauthorized access, disclosure, alteration, loss, or destruction of personal data. It is a security incident that compromises the confidentiality, integrity, or availability of personal data. Organizations are required to report certain types of data breaches to the relevant supervisory authority and, in some cases, to the individuals affected. Rights of the data subject refer to the entitlements of individuals regarding the processing of their personal data. These rights aim to empower individuals to have control over their personal information. Key rights under GDPR include the right to be informed, the right of access, the right to rectification, the right to erasure, right to be forgotten, the right to restrict processing, the right to data portability, the right to object, and rights in relation to automated decision-making and profiling. Each right has specific conditions and exemptions, critical for organizations to understand and implement effectively. International data transfers involve moving personal data outside the jurisdiction in which it was collected, potentially subjecting it to different data protection laws. Given the global nature of the Internet and international business, these transfers are common but regulated under data protection laws like GDPR. Transfers require adequate protections, such as standard contractual clauses, SCCs, binding corporate rules, BCRs, or adequacy decisions, to ensure that data is protected to a standard equivalent to that in its original jurisdiction. Privacy by design and by default is a principle that calls for privacy to be integrated into the development and operation of IT systems, networked infrastructure, and business practices. It requires that privacy is considered not as an afterthought but as a key component of the design process from the ground up. By default, systems and services should collect the minimum amount of personal data needed for the specified purpose, ensuring that data is not unnecessarily or inadvertently processed. Data Protection Impact Assessment, DPIA, is a process to help identify and minimize the data protection risks of a project or plan. DPIAs are required for processing operations that are likely to result in a high risk to the rights and freedoms of individuals, such as large-scale processing of sensitive data, systematic monitoring of public areas, or the use of new technologies. The DPIA must be carried out before the processing begins and needs to address the nature, scope, context, and purposes of the processing, as well as the risks and measures to mitigate those risks. Anonymization and pseudonymization are techniques used to protect personal data by altering the way information can be linked to an individual. Anonymization irreversibly prevents identification, ensuring that an individual cannot be identified by any means. Pseudonymization, on the other hand, replaces identifying information with artificial identifiers or pseudonyms, making it more difficult but not impossible to link data back to the individual without additional information. Both techniques are valuable for enhancing privacy but have different legal and practical implications. Legitimate interest is one of the legal bases for processing personal data under the GDPR and other privacy laws. It allows organizations to process personal data without explicit consent if they have a genuine and legitimate reason, including commercial or societal reasons, provided this is not outweighed by harm to individuals' rights and interests. Determining legitimate interest requires a careful balance test, considering the necessity of the processing and the impact on the individual. Data minimization is a principle that stresses the importance of limiting personal data collection to what is directly relevant and necessary to accomplish a specified purpose. It aims to reduce the risks associated with data retention and protect individual privacy by ensuring that only the minimal amount of data required for a specific task is processed. This principle is crucial for maintaining trust and reducing the likelihood of data breaches and misuse. Encryption is a fundamental security technique used to protect personal data by converting it into a code to prevent unauthorized access. It is an essential tool in the protection of data both at rest and in transit, ensuring that even if data is intercepted or accessed without authorization, it remains unintelligible and secure from breaches. Understanding and implementing strong encryption methods is a key aspect of compliance with data protection standards. Data Subject Access Requests, DSARs, empower individuals to request access to the personal data that an organization holds about them. This right enables individuals to understand how and why their data is being used, as well as to check that it is being processed lawfully. Fulfilling DSARs is a legal requirement under GDPR and other privacy regulations, emphasizing transparency and the individual's control over the personal information. Privacy-enhancing technologies, PETs, are tools and methods designed to protect users' privacy by minimizing personal data use without losing the functionality of an information system. PETs include techniques like anonymization, pseudonymization, encryption, and secure multi-party computation. They play a critical role in enabling privacy by design and helping organizations meet their data protection obligations while still leveraging data for business operations.